is the next legal update for people that are interested in what's going on in the Gulf Harbour community from a legal perspective. There are 6 items that I think will be of interest to you, and I'll go through those one at a time. First of all, I want to talk about the class action that we are planning to bring against Long River. The basis of that is that the closure of the golf course significantly reduced values of houses around the golf course and indeed in the whole of the precinct. Now, it doesn't really matter whether your house is on the golf course directly or whether it's simply somewhere in the precinct. Our advice is that all property values have been devalued to some extent. Obviously, those that are on the golf course directly or have views of the golf course will have suffered a higher loss than those that do not directly impact on the golf course. So the statement of claim has been drafted in this way. We are naming Long River Investments Corporation Limited as the first defendant. GHCC 2016, which is the company that we've put into liquidation, will be the second defendant. And then we've also named Greg Oliver in his personal capacity and Wayne Bailey in his personal capacity as defendants. We've identified 7 courses of action, and that will be included in our statement of claim. At the moment, that statement of claim is with our barristers who are reviewing it, and hopefully I'll be in a position in the not too distant future to report back to you on that. The idea of a class action in New Zealand is covered under what is called section 4.24 of the High Court rules. So those rules basically are called a representative action rather than a class action, but I'll continue to refer to it as a class action because I think that's what most people probably understand. And what it says is that where people have a common interest, they can join together as a class to bring this representative action. And what it means, of course, is that the costs, instead of being taken up by just one person or 2 people or whatever, will be met by, in this case, KWGS, so that it won't cost anybody that wants to participate in the action any money at all. Now, with those 7 causes of action, some of those are going to be directly against Long River and some of them will be against Oliver and Bailey as individuals. The next step that we're going to take here is for the property owners who are interested in participating in the class action will sign what's called an opt-in form. We will get those out to you once we've had our barristers review the statement of claim, but it may take another few months to get to that stage, but that's the progress that's being made there. So it's important to appreciate that because this action, this class action, is based on a breach of the encumbrance, it's important to understand that because it's based on that encumbrance, and an encumbrance, what we call runs with the land, it means that any subsequent purchaser, whether they were involved with Oliver from the beginning or not, doesn't really matter, any subsequent purchaser of the golf course land is going to face exactly the same problem. And that is particularly powerful because if they can see, which they will be able to, that there is a very significant class action being commenced, the value of the golf club land once again is somewhat less than it might otherwise be. So that's important to appreciate, that this class action effectively will bind or will be lodged on any subsequent purchaser as well as Long River if they're still around. So the next point that I want to talk about is the liquidation of GHCC 2016 Limited. Now, as you know, we had the debts assigned to KWGS by those members of the golf course who were owed money by 2016, and after the normal legal proceedings and the time taken, which unfortunately is a little longer than we would have liked, we got a liquidation order from the High Court and we appointed the liquidators Waterstone Group Limited. and they have now been for the last few months going through the accounts, following up on documentation, etc. And what they have discovered, amongst other things, is that there is a debt owed by Long River to GHCC 2016, which is something a little over $60,000. So what the liquidators have done is they have filed what's called a statutory demand on Long River, and that has been served on the sole director, Wayne Bailey, who is currently residing in Melbourne. Now, depending on what action they take, they may dispute the statutory demand, they may not, but one way or the other, the next step will be a liquidation hearing. And of course we look forward to that with some interest as to whether the amount will be paid. Possibly not, we don't know yet at this stage, but in any event, it's quite a positive action on our part to start that liquidation proceedings against Long River. Now, I'll also talk about the next point is the bankruptcy application against Greg Oliver personally. You may recall that this was bought by the BNZ last year, and it has now gone through several adjournments, and I hate to report to you, but there has been a further adjournment. This will be the third adjournment. We're not quite sure what is going on. BNZ seemed very comfortable with proceeding with personal bankruptcy, and we're trying to ascertain exactly what happened at the last hearing, which was only a matter of a few weeks ago. So once we have something, we will be updating you with respect to that, but we're not aware of any reason why that application was adjourned for a third time. There's been another development in terms of a new caveat being registered on the Long River land. And that's been registered by a company called K3 Legal. Now, it's most unusual for anybody who is simply pursuing a trade debt to be able to register a mortgage on land. In fact, they can't. You have to have what's called a caveatable interest, and a normal trade creditor does not have a caveatable interest. So what it means is that K3 Legal somehow or other have probably persuaded Oliver or Long River to sign an unregistered mortgage. Now, an unregistered mortgage does provide K3 Legal, if this is how they've done it, with a caveatable interest, and we suspect that that's what's happened. Now, why have they done that? Well, the obvious reason is that they either haven't been paid their fees or they are expecting some issue over their fees, and so they've tried to protect them by taking a caveat over the golf course land. Unfortunately, they will all be aware now that Greg Oliver walks away from debts all over the place, and so I guess they're trying to protect their interests in some way. So that's the status of that. Now, there's also been another stat demand filed on Long River, not for a huge amount of money, but it's a stat demand that we understand has been filed by a planning company who were probably involved in the judicial review process, which I'll come to in a minute. But in any event, they haven't been paid, and so they have gone down the stat demand route, and in due course they will have the capability, assuming the High Court gives approval to do so, to commence liquidation proceedings against Long River as well. So it's all sort of building up. We're feeling very comfortable that by one course or another, we will get to the stage where Long River will be liquidated, and that will mean ultimately that the land will go up for sale. We're not expecting anybody to bid a particularly high amount on that, and it may be that we can have some influence over how that auction goes ahead, or whatever the sale process is. But if you look at the value of that land as a golf course, and of course with the encumbrance, and as you know, we have had council support reinforcing that the encumbrance is a permanent fixture. What it means is that you have to value it as a golf course, and you can't value it as if it's a development or even a potential development of residential land. And so you might say, okay, so how do you value a golf course? And we think that the only way you can meaningfully value it is to say, if the golf course was put back into the condition that it was previously, that over a period of time membership was built up, what would be the potential profit that could be made from the golf course, and then apply what we call an earnings multiplier. So the work that we have done in determining what the potential profit could be if it were put back into Class A condition is that it would be possibly make $1 million a year. That may be a bit of a struggle, but let's say it can make $1 million a year once the membership's built up and all the work has been done. Now, if you then apply a typical New Zealand type PE ratio to that, you might say that it's 6 times. So that would mean that the value of the golf course, if you assume that model of valuation, would be somewhere in the vicinity of $6 million. A very far cry, of course, from what we understand was paid by Oliver when he purchased the shares in Long River, which we understand was in the vicinity of $24 million. So that's sort of where that sits at the moment. We can't see any third party wanting to bid anything like what we now understand to be the amount owing on the first mortgage, which is well north of $50 million at the moment because of penalty interest and interest costs that have built up. And of course there's been no repayment of any of those under the mortgage. So the mortgage is well and truly in default and has been for, we guess, about 2 years. So that's the status there. Now the next one I want to talk about is the judicial review hearing. Now you'll recall that the council commissioners determined that the resource application that was sought by Long River to alter the boundaries of the land, being the first step towards a construction of residential housing on the golf course, at least the first 9 holes, if not ultimately the whole lot, was determined by the Commissioner to be an application that needed to be notified. Now that was particularly important and was welcomed by us, because what it meant is that KWGS and indeed any other affected party would have the ability to put in submissions when that hearing finally eventuated. And it also meant that in the event that for any reason the resource consent was granted, we would have the right of appeal, as would anybody else who was involved. If, on the other hand, the resource consent had been determined to be non-notified, we would have had no right to put any submissions in, and we would have had no right to appeal in the event that it went against what we believed would be the correct decision. So we're very happy with that. Now then some time went on, a matter of quite a few months in fact, and all of a sudden last year a judicial review proceeding was filed by Long River. And that judicial review proceeding challenged the Commissioner's decision to notify the application. Now you'll recall that at the time the application was put in, we KWGS made substantial submissions as to why it should be a notified hearing. The recent decision by the High Court judge, I'm pleased to say, basically threw out Oliver's application to have it non-notified or go back for review by the council. And what was particularly pleasing was that the judge in that decision pretty much followed exactly the logic and the submissions that we had put in previously. So all of that was very pleasing. Of course there will be the issue of costs, and because Oliver lost, then the council, who was the respondent to the application, will be seeking costs from Long River. And that in itself may give rise to another stat demand in due course if those are not paid. So the pressure keeps building. Now you'll also be aware that the Auckland Council made the decision to demolish the building, the clubhouse building, when it was burnt down. And the cost of that, we understand, was in the vicinity of $250,000 to $275,000. And they have now sought repayment of that from Long River. And we believe that it has been set down for a hearing for later this year. And so that may end up also possibly being another application for a stat demand if that's not paid by Long River. So again, just one more nail in the coffin of getting to the stage where Long River is going to be put into liquidation. So that's about it for the time being. We will keep you informed as things develop. Here's a summary then of the 7 points we've discussed. Firstly, class action against Long River. KWGS is planning a class action against Long River, GHCC 2016 Limited, Greg Oliver and Wayne Bailey because the golf course closure significantly reduced property values in the Gulf Harbour community. The statement of claim, identifying 7 causes of action, is currently being reviewed by our barristers, and property owners will soon be able to sign opt-in forms to participate at no cost to them. Secondly, liquidation of GHCC 2016 Limited. KWGS successfully obtained a High Court liquidation order for GHCC 2016, with Waterstone Group Limited appointed as the liquidators. Liquidators have subsequently discovered a debt of over $60,000 owed by Long River to GHCC 2016 and have filed a statutory demand on Long River, which may lead to further liquidation proceedings related to Long River. Thirdly, the bankruptcy application against Greg Oliver personally. The BNZ's personal bankruptcy application against Greg Oliver has experienced a third adjournment, with KWGS trying to ascertain the reason for this delay. While the BNZ previously seemed comfortable proceeding, the exact circumstances of the recent hearing are unclear. Point 4. A new caveat on Long River land. A new caveat has been registered on the Long River land by K3 Legal. Now, this is unusual for a trade debt. KWGS suspects that K3 Legal obtained this caveatable interest by persuading Long River to sign an unregistered mortgage likely to protect their unpaid fees. Fifthly, another statutory demand on Long River. A planning company has filed another statutory demand on Long River for an unpaid debt. Likely this was related to the judicial review process. This action means the planning company could also commence liquidation proceedings against Long River if the debt remains unpaid. Sixthly, judicial review hearing. The High Court judge dismissed Long River's judicial review application and upheld the Council Commissioner's decision to notify the resource consent application related to land boundary alterations. This outcome was a significant win for KWGS as it ensures affected parties retain the right to submit an appeal concerning any potential development, and may also lead to the council seeking costs from Long River. And lastly, the Auckland Council is seeking demolition costs. The Auckland Council is seeking repayment from Long River for the demolition costs of the burnt down clubhouse building, and this is estimated at $250,000 to $275,000. A hearing on this matter is scheduled for later in the year, and of course it may also lead to another statutory demand made against Long River if those costs are not paid. Thank you for the time to keep up to date with these developments, and we will be doing further legal updates as matters come to our attention. Thank you.